Leave it like this, I think. Oh, here comes the judge. Here we go. Ooh, I guess there's no one in the gallery except the police. That's interesting. All right, guys, I'm going to leave it. And the sound machine is lower again. Hey, Blair. She does have glasses.
Yes.
Good morning, Your Honor. Alexander Buckle on behalf of the state.
On behalf of the city.
Taylor Collins on behalf of the state.
Justin Griffiths for the state.
Good morning, Stu Allison and Benjamin. Danny Aronson on behalf of Melly and Ms. President.
I think Ms. Liberty is on.
Miss Liberty is on Zoom. She got stuck in traffic.
Stuck in traffic?
Good morning, Judge.
Get her the fuck off Zoom. Leave earlier. Leave earlier.
I take it you're trying to get your puppy.
I'm sorry, Your Honor?
I take it you are trying to get.
Yes, Your Honor. I am appointed as the prosecutor on the case.
Thank you. All right, so I don't know where we're at. I received a notice to court of party signed by counsel the other day. I assume you all did it. You all received the same document as well. I don't know if you had a chance to speak about it with the parties or not. Where everybody is on this notice to court and party.
We have not spoken to the state about the motion. Certainly, we won't object to the proposal. We would go into detail as to why.
What are you proposing?
We propose to proceed, as Your Honor indicated, we've agreed to take the depots on Friday, Saturday, and Sunday of the new witnesses. It's our understanding that the court would do motions while we are picking a jury. Basically, their proposal is a way to benefit themselves and usurp the speedy trial rights of our client. He sits here and they want him to sit another 3 to 4 months
This is as loud as it goes, by the way.
because of what.
So they fixed the sound machine, but now you can't hear anyone.
This issue has been pending since, as the court knows.
Counsel, I'm not, I don't need any argument on it. Respectfully, it's the concern, this was brought to my attention earlier, last week or this week. The same basically concept was brought by the state sidebar, and I indicated it's not, I mean, to me, it's just kind of circumvent the speed trial.
Exactly.
And if everybody agreed to it, it's one thing. If you're saying that, with this, everybody's on board with the same situation, that's one thing. If it's not, I don't know that I would do that if the defense objected. Just, have you ever had any cases where, you're saying that the parties agreed to on a murder case, state seeking the death penalty, where you say, okay, speedy trial, run in a couple of days, we'll go ahead and swear a jury in and then come back next year, 2-3 months down the road?
A case or a case, I don't have on hand, but it's happening in the courthouse on many. I've seen it happening in trials that I'm doing, because of all the time involved, and all the jurors.
I understand there's a whole host of time involved. I'm very sensitive to the fact that this defendant is, on a retrial, speed trial time is running, and there's all kinds of motions that were filed recently, within the last 2 weeks or so as well. I think there's up to 30 now, and as well as a witness list by the state, which added, according to your notice, Mr. appointed 22 new witnesses. So I don't see how the parties are ready for trial, mechanically. But on the other hand, the defendant has a right to a speedy trial. If he doesn't want to waive that right, my thought is that the court shouldn't be trying to do something that circumvents his speedy trial rights. So, that would be a no. I'm not interested in it. So these motions that you have, there's I think 30 of them, last count. You're interested in having these motions heard, or you're interested in going forward to the trial?
I'm not sure that's an either or. Is that the court's giving us either we do the motions and
I don't know if we're gonna pick jury, we're gonna start picking a jury, that's fine, but I'm gonna be in here doing jury. I've got other cases, other dockets, I'm sure you do as well. I don't know which cases we're gonna, what motions, if any, we're gonna be able to handle or not. You also said Fridays, you want to take depositions, I don't know if that's due to the state. I guess you have to work those things out, and we will see where it goes. But you filed, in excess of 30 motions, and you're saying you're ready for trial. You're ready for trial?
Yes.
All right, and so the defendant has a right to have I guess, a continuance if he wants to waive speedy trial to take all these depositions, but you're not asking for a speedy, to waive the.
No, we're not.
So you want to go forward?
Yes, sir.
Go ahead,
They're
sir.
ready, Your Honor, and I guess they don't have any, they are not gonna matter whether they hear the motions or not, they're ready to go. Well, they're putting the court in a position, they're saying, we want the court to hear all these motions that we filed, but on the other hand, we're not waiting our speedy trial. Right, well, which one do they want?
Correct. So, that's the curriculum we're in. We're just gonna, we'll do the best we can. That's all we can ever do. We'll do the best we can.
Your Honor, if I may, I'm sorry. So, as someone who just tried a speedy trial case, we picked the jury in July and brought them back in September. That was due to health issues, scheduling issues for motions. There was about 10 or 12 motions that had been filed in that case. And we got, and some depositions that were outstanding. We got all of that done after we brought up a panel, swore them.
Which case?
It was in front of Judge Holden, State versus Gregory County. We just did that, and we relied on the case law that was cited in the memorandum that was provided to Your Honor. Now, I understand that the defendant has to be challenged, and I understand that we need to move this case along. But as Your Honor is very aware, this is a very serious case. And just like the defendant, the state is also entitled to a fair trial. And myself and the co-counsel in this case, we just got this case 48 hours ago, and we know nothing. And in order to appropriately represent the state, and we'll still be at a disadvantage, because Bruce Bradley had this case for 5 years, she lived it. We will still be at a disadvantage. So if Your Honor's not willing to bring them back in January, at least give us till December to at least get up to speed on the case. We might be able to work some things out, move the case along faster. It would streamline things, honestly. So the case law does allow Your Honor to bring up a panel due to all the motions that have been filed by defense. It would also allow us time to figure out the case and be prepared properly to represent the state.
My thought is, I guess, different than that. I looked specifically at cases that basically went up on appeal on the issue. I didn't see them, and that's why I was asking Mr. Klingman to be acting in cases where that issue came up, the objection was posed, and just saying that we'll come back in 2 or 3 months is okay. I haven't seen any cases like that, and that's why I was asking Mr. Klingman, my understanding is that he doesn't have any.
Although the two cases that are cited in Gaines and State Versus Gaines 770771221 and Knight versus State 2117311 2016, both of them are 16 court. So those cases saying that
It worked. It worked.
and there's discharge. Certainly in Gaines, I'm sorry, Knight, that would be the issue. And the Supreme Court of Florida said, no, you can't bring a motion for discharge if in fact the veneer was sworn for purposes of quasi. So they clearly, Florida Supreme Court said, no, that way, that's the end of the speedy trial. For speedy trial, the trial begins when that video, that first panel that comes up for questions this morning. Then they said, but if you're asking when double jeopardy attaches, that attaches when you have the final panel, you've gone through all your jury selection. You've chosen 12 people and alternates. And when the court swears those 12 people and those alternates in, the Supreme Court says, then the trial commences for purposes of testimony, and therefore double jeopardy attaches. So although I don't have a case where it was appealed directly from here, concerning these issues, with that this procedure is involved in the courthouse on many occasions without any and the Supreme Court in Knight versus State is extraordinarily clear about the fact delineating when the trial starts for purposes of the trial and when the trial starts for purposes of the trial. And added into that case law that has to do with how the state loses its appellate rights when trial commences. That is, when those final juries, 12 or 11, are sworn in. We no longer are able to appeal a motion to suppress that right. If the court issues us an order, maybe the argument was done pre-trial, but the court was busy and the court didn't issue the order until afterwards, you can't appeal it. You can't even take an extraordinary writ.
Now the audio is completely off.
One of the reasons you don't
What
see
the
much
fuck,
on this
man?
is because it's a pretty set down rule of when trial commences for speedy trial and when it commences for double jeopardy. And therefore, the level of playing field here for the state, which is at a great disadvantage at this point, there's no problem with the court swearing in a panel for a veneer and then asking them to come back at a later time before it gives parties time. They don't want to continue, they don't have time to do it.
This is as loud as it gets, folks. I don't know what they're doing.
We all understand, we don't disagree with that being the law on when they can appeal, when speedy trial. We're not even talking about that here. We're talking about, Your Honor set a date for the cutoff date for filing motions. We abided by it, and we filed motions. We're not here to give up.
Bald asshole.
Those motions heard, nor do we believe that speedy trial trumps the fact of us not having the ability to have those motions heard before Your Honor. And whatever schedule that this court picks or chooses to do that, the defendant has an absolute right to have those motions heard when the court can do it. But I don't think we have to say, oh, but we're going to give up our speedy trial rights in order to do that. There was a time, Your Honor, almost a month ago, where you asked Ms. Bradley, if you're going to be unable to be the lawyer in this case, what arrangements are you making to have, who's going to try this case? And she said, well, we'll cross that bridge when we come to it. They're in.
Oh, shit. Joe, giving out a subscription. Thank you so much, Joe. Welcome, Reapy HD2. Thank you so much, Joe. And it looks like the audio is back, folks. Thank you, Joe.
Such a disadvantage. Marcy's law applies. What about the fact of Mr. Bevan's rights? They're premier and paramount to anything that goes at this point. And I would, respectfully tell you, Your Honor, that we don't have to give up our rights to have those motions heard because it's being tried. And that's just, I think, unheard of. And we abided by the court's order when we filed. So whatever he wants you to listen to about the law, the state wants you to listen to about the law when, double jeopardy happens and all that, that's fine and good, but that doesn't bring us to where we are now, that we will work as hard as possible whenever we can to be able to have these motions heard because they're filed in good faith, and we believe that the issues there are vastly important to the defendant, but they need to be heard, we will see. And they were timely filed according to Your Honor's orders. And Mr. Erickson wanted me to add, Judge, that bless his heart. They had a second jury in the first trial, who knows his case backwards and forwards. She sat through it. Where'd she go? She still works for the office. So if they want to do whatever they want to do and assign or appoint whoever they want, and then stand behind that appointment by saying, oh, we're not ready, it's not fair to the victim's family because they appointed somebody who's not familiar with the case, when there's an absolute lawyer who sat through the whole case for the last 5 years who isn't here, who's not here. So and if you look at the, and I don't want to argue the whole thing, but if you look at the arguments in their notice of filing, they have the audacity to talk about the Queensberry rules of fist fighting in there. This isn't a fist fight. This is an accusation that could carry the death sentence of a defendant who hasn't been proved guilty because they haven't met their burden, and we don't think he's guilty. So I don't want to have a fight with Mr. Klinger. I want to have a trial, a fair trial, have the motions heard, and do what we need to do that's right for preserving any issues, having Your Honor throw out evidence if you so find after hearing the motion, and do a real trial. That's what we're trying to get done.
They filed the motion, for the office, all the protocol. And this court took the time and had hearings, been here for the last couple of weeks on those motions, and you ruled. The court ruled, Mrs. Bradley is off the case. And so at that point, we had obviously been providing a new trial. The reason why, it's not any of their business findings, emails that will be on the trial, but you cannot be this trial. So it doesn't matter. Therefore, the reason I put that case in there, Billback, that was decades. And in Billback, at the time, originally, time of that television, there was no rule on the state being allowed to have an expert at death penalty interview the defendant. There was no rule at all. So the court in that case actually went outward the boundaries and said, but in this case, the court feels the state should be allowed to do it. And that's what went up on part of it, that went up on appeal. And the defense saying, no, the court has no right to allow the defense, the state, to send their expert in to see our client. The Supreme Court said, that's when they refer to the boxing situation, they're using it as an analogy, because it's not right if the playing field is not level, and that the court has the ability to level that playing field. And they agreed with the trial court that it made the right decision of allowing the state's expert to go in and see the defendant, because they have so many experts in their decision. And they use part of the reason because it needs to be a level playing field. One side shouldn't have an advantage over the other side. And in that case, the court had to do something very dramatic, right? There was no rule on it. Here, we're not asking you to step over any boundary. We're simply asking you, again, as I outlined in the notice, to follow well-established law of when Sweden, when trial convictions for double jeopardy. The defense, in a way, has gotten what they wanted, and now it seems like a very disingenuous argument when they know that the state's got a disadvantage. They say, well, we have all these motions we want to convert, but we're not going to continue. That's an issue for the court, and the court may deal with it. But from the state's point of view, we don't deserve to not be on a level playing field. To just have these prosecutors designed for the case when there is a way where their motions can all be heard without them having to take a defense continuum, and where the state can be ready to answer the motions, argue, and also answer them.
Your Honor, if I may, I just want to put a few cases on the record. Smart v. State, 179, Southern 3rd, 477 is the fourth PCA case. That also discusses how the District Court of Appeal held that the trial had begun for speedy trial purposes when the prospective jury had been sworn, pre-voir dire had begun. So they said when the panel was sworn for this particular case, that was when the speedy trial was satisfied. Now I'd also like to put on the record Casimir, C-A-S-I-M-I-R, McDonough, M-C-D-O-N-O-U-G-H, It is a third PCA case, and it's 932 Southern 2nd, 471, 2006 case. And it discusses how in that case there was a 13-day continuance between jury selection and the examination of witnesses, and it did not entitle the defendant to discharge of charges. It also cites other cases that discuss a 24-day delay was permissible between the conclusion of 1 year and the commencement of trial, an 11-day delay, no showing of prejudice, 12-day delay, no showing of prejudice. So there are cases showing that there can be a time frame in between swearing the veneer and bringing the jurors back to truly start the trial. As I said, if Your Honor is not willing to wait until after the holidays, we are asking you at least until December to have somewhat of a chance to learn this case. There's just no other way. Yes,
Mr. Counsel?
I can print more copies, Your Honor.
Judge, we're not contesting when the speedy trial starts, or when you bring down the veneer and swear them in. We're not contesting that. What we are contesting is Your Honor issued a pretrial order that said all motions must be filed by 10 days before trial. We have complied with that. The state created this mess. They have sat on this mess for a year. And now to come in here and say, despite creating this mess, we should be given additional time, disregarding our client's rights, and sitting here as presumed innocent of these crimes, is absurd. And we're willing to work around the clock to do these motions that were timely filed. I mean, I don't know what the problem is, to be honest with you. We agree that speedy trial basically is satisfied once you bring down a panel and swear them in on the state of Florida versus Dennis. We agree. That's the law. I'm not standing here to misrepresent the law as an officer of the court. What we're saying to Your Honor is you are allowing the state to cause this problem and now benefit from it. They were on notice a long time ago. They were on notice, actually, when Michelle Boutros reported this thing back in October of 2022. And they sat on it. And they sat on it until we had to litigate it, until we were advised of it. And as soon as we were advised of the problem, we filed the appropriate motion. Under their scenario, they could usurp the speedy trial rule anytime they want by basically creating a problem that they knew about over a year ago. So I would ask Your Honor to, whatever scheduling you want, to do the motion that were timely filed, to do the motion, and to commence jury selection. And we will take the appropriate deposition, as we've indicated, Saturday and Sunday, or whatever days we're off, if we're off any. The court indicated originally, I thought, that he would probably do the motions on a Friday. And we would go through the motions. Because we all know it's going to take probably a month to pick a jury, if not longer, because of the holidays. If they don't like a ruling of the court, before that jury is sworn in, they can take an appeal. Because we agree jeopardy doesn't attach until the actual 12 or 14 or whatever you pick are sworn to hear the testimony. We agree with that law completely. But I don't know why they should benefit. And we should be deprived of his rights. And he should sit in jail another Christmas and New Year's. No, sir.
Your Honor, I know you don't like a lot of people, but this case was just handed to us, so if I might. As far as the delays that this case cites to, this is the Casimir case. Bottom line of it is, other than one case, which obviously I don't have access to, Johnson versus State, there's a flag in front of it, which obviously means it's either been disagreed with or has been modified. Every other case that this case cites, you're talking about a 12-day delay or an 11-day delay. We're not talking what the state is asking for in this case. What the state is asking for, if you look at the document that they filed, I mean, I couldn't believe it when I read it, because to me it was an inter-office memo of how we can deprive the defendant of his speedy trial rights. What can we do in order to get around his speedy trial rights? That's what that document is. These cases are 11, 12 days. That's what these cases are that are cited in Kashmir. That's all the delay was, except for that one case, which I have no idea why there's the flag there. That's a little more.
Thank you. Yes.
Just quickly looking over the case, Kashmir, they're talking about a delay after the actual jury itself, the culprit was sworn. And they're looking at delays. Because now you're in trial, right? Once they're sworn, trial starts. Double it. The case does not actually discuss when you're still in jury selection.
You're the one who gave us the case.
So, but the analogy is there that if.
But it doesn't apply.
So I should be dishonest at court and not level of court. I've never been, I don't do that. So, but the analogy is there that, look, if they're even finding the fact that there can be delays between the actual juries and when there's a delay, that is okay in circumstances. So when you're just still doing jury selection goes on forever. I mean, the court could, if it wanted to, bring panels in here and there, just to go over to see whether or not they're going to be able to have the time and the ability to stay on the trial. I mean, certainly, in the state of Florida versus Nicholas Cruz, it took us 3 months, I believe, maybe 2.5 months to get a jury. Panels came in at all different times during that trial. And that was in 2022. So these rigid rules about how long a delay can be when you have a jury apply more to when the actual jury is sworn, and not to the near panel that's sworn. In order to start the process. And so, you know, again, it's usable to the state. They're following your orders. There is no appeal, and it is very reasonable for us to at least ask the court to come up with a way that would allow us all extra time. They don't need to continue and they can make a motion. There. It's not foul play. It's not trying to get around the rules. It's simply following the rules and doing what's fair to the whole thing.
So what days, assuming we're going to start, what days will you start getting jury tomorrow? Or what days, I'm swearing the jury in one way or the other, right?
Yeah, that's right.
So whether I agree with the state and to hold off on it or not, we're going to start picking a panel tomorrow. I don't know when you're anticipating. I know witness Bradley was here. She had issues with child care and everything else. She was knocking off all kinds of days. I think it was 2 weeks after Christmas. And, I don't know exactly when the days were, but I do know that she marked a substantial number of days off for the holidays for she had minor children in school. I don't know that depends on the same position as the state did. I don't know what your position is, what you're looking to do assuming we're starting the jury selection.
Your Honor, I did speak with local counsel on this case and written out the days that we would not be unavailable. I don't know what Ms. Bradley's availability was, but there are a few days here and there, and obviously the holidays are taken into consideration as well. But there are a few days here and there.
So what days are you unavailable?
So obviously tomorrow is the here, but myself and Ms. Collins will be here. On Thursday, Ms. Collins will not be here.
So what day are we talking about now?
I'm not talking about the 19th of October.
So, state's available on the 18th,
Most of us, yes, so we will be here.
19th?
Ms. Collins is not available, but I can.
What about on the 23rd?
I know that some of us have unavailability in the afternoon.
What's the unavailability?
I do have that.
It's not you, it's...
No. And then the 26th, both of my patients are not available.
We're good on the 24th, 25th, and not on the 26th.
Correct.
So far we have 18th, 19th, 24th, and 26th. And you're saying you're available, is that right?
Yes.
What about the rest of our
We're fine.
31st,
We're okay.
so 18th, 19th, 24th, 25th, 30th, 31st, is that right?
18th, 19th, 24th, 25th, 30th, 31st.
You're available. In October, you guys available?
I just had one doctor's appointment Thursday late afternoon, Friday the 19th. But it should be about an hour, and I don't know if all of us need to be there for the jury selection, but we didn't contemplate it, but I don't.
I'm asking you.
Oh,
We're fine.
yeah, we're fine. No, we're fine,
Good,
we're fine.
good to go.
Yes.
So how about November?
And just so I'm clear, you're doing this, just, you're not moving one way or the other what we're doing. So I have on November 2nd, Your Honor, that I'm unavailable in the afternoon. I just cannot remember why. I think that might be a doctor's appointment.
You're good on the first,
Yes.
not on the second. How about the week of the sixth?
Week of the 6th, all parties for the state are available.
Week of the 13th,
Your Honor, I am out the 13th, 14th, and 15th.
you're good on the 16th.
Yes.
How about the week of the 20th?
All parties are available, the 20th, 21st, and 22nd, and obviously the office is closed the 23rd and 24th.
So Judge, based on the previous schedule we had reached with Ms. Bradley, I was planning on leaving the 17th and being out that week of Thanksgiving.
Thank you. We'll get to you in a second.
Get her the fuck off Zoom. Are you fucking kidding me? Everyone else could be there on time, but she didn't leave in time in traffic, so she's on Zoom. Turn that fucking TV off and get her the fuck out of there. That is some bullshit. Everyone else is there on time, but Miss Liberty couldn't make it, so she's Zooming from the car like it's fucking DeSantos Court. Get her out of there.
How about the last week in November?
Mr. Curtis is unavailable that entire week.
So regarding the defense in November, are you all good the first?
Yes. Yeah, we did it. Yes.
How about the 6th, 7th, and 8th, 6th, 7th, 8th, and 9th?
Some combination of us. Yes, we're fine.
Good. Then the next is the week of the 13th, is if there stays not available, then we come back on the 20th, the 1st, and the 22nd, but all I heard Ms. Raven said she's not available. You mentioned the 17th, is that right, Ms. Liberty?
Well, if she's not available, fuck off. It's not, I mean, you guys got 4 lawyers. You're not going to have a date for there's literally 6 lawyers. She can't even make it to court on time. Get her off Zoom.
Yes, Judge, based on our last schedule, I had planned to go home for the 17th, the week of Thanksgiving.
So that's the 17th, 20th, 21st, 22nd, so you're not available those days.
No, Judge.
And the last week, 27th, 28th, 29th, 30th of November, you're good, Vince?
Yes.
Yes. Ms. Liberty, you're good?
Yes, Judge.
All right, how about in December? How about for the
Your Honor,
state in December?
Your Honor, the only unavailability that the state has is starting December 21st through the 31st.
First through the 31st, you're not available, otherwise, you're good to go. And how about for the defense? First through 20.
Sorry, guys. They are streaming this underwater. You can't tell, but they're underwater right now.
Yes? Yes. Back in January, the first week in January.
Ms. Collins is good, and then I think Mr. Griffiths is checking his calendar.
I'm good from January, potentially out the 29th through February 2nd. Actually, the 29th through February 9th. I have to double check those dates.
So the state's relatively as good in January.
I'm going to have to double check my schedule, but February was going to be rough. I have to get confirmation of the date. February is I'm going to have to get back to you.
Days in October, November, roughly half the month of December through the 20th is good. January is good. February, not sure. So we'll figure this out. My concern really was not specific days. I try to work with the attorneys if they have medical appointments, something like that. But I was more trying to get up for vacations here for the Christmas and Thanksgiving holidays. I haven't read your case, I'll take a look at it. How about with regard to Monday through Thursday, I'm not being in session on Fridays. That's the way I explained it and discussed it with the council. I wanted it all 5 days, Mr. Bradley on Monday through 4. And we'll go back to the rest of that. Defense counsel also said they have certain things they might want to add on Fridays, but they're good with that, just Monday through Thursday.
We're good with Monday through Thursday, and obviously we do have motions that we need to have heard. I'm not opposed to using some of the Fridays, but obviously we need time to one, learn the motion from the case, and also prepare on some of the Fridays that we would have to utilize. But we're not opposed to utilizing some of the time on Fridays. But I think we would have to obviously review the case, know the evidence, and see which motions we.
My tiny mic had 1,000 times better quality than this shit. The one I got for $20 on Amazon.
We're back December 4th and start with full-blown jury selection after that. And what's best to streamline the case, and that way myself and my co-counsels can utilize their time effectively the rest of this month and next month since the majority of counsel are not available.
We're fine with this, though. We're fine with it. May we have a moment?
We'll be in recess for a minute. Can I see your signature?
So much, Kim.
Thanks a lot, man.
Guys, am I hearing this correctly that jury selection is going to be tomorrow? Because that's what I thought I heard. And they're trying to figure out their schedule for... The audio is crystal clear on Law and Crime, so it's me this whole time? All right, I just refreshed it. Maybe that'll fix it. Sorry, that was up me.
And also prepare on some of the Fridays.
We're live now. So anyway, did they say jury selection tomorrow? Or was that just me that heard that? There's Gary. Meow. Yeah, it's you, pal. Good morning, Dawn. It sounded like they're saying jury selection tomorrow, but I don't have a confirmation of that. Good morning, Fuzzy Puff. So, I mean, there's like 30 motions pending, but defense counsel's not waiving their right to a speedy trial, so they got to get this thing going. We do have a new attorney for the state, which it sounded like her last name was Buffalo, but I don't know. Kim is feeling so much better, Gary doesn't even make her mad. Well, I'm glad to hear that, Kim. Good morning, Elizabeth. Betty C., you're welcome. Well, thanks for being here, everyone. I appreciate it. It will be quite interesting to see if we are having jury select tomorrow. I mean, they were trying to figure out their schedule for October, so like tomorrow's in the rest of the week, it sounded like it was so freaking hard to hear. But I mean, he has a constitutional right for a speedy trial, and they don't want to give it up. And I don't blame him. I mean, they made a good point. The state fucked this up. They got to get their shit together. It's not the defense's fault that the state did some shady stuff, or Moretti did, and that there was a person in the state's office who said this was shady, and they kind of ignored it and didn't let the defense know. That's on the state. Buckle up, buttercups. Melly has a right to a speedy trial. I mean, I think he's guilty, but he's got a right to a speedy trial. He's in jail in solitary confinement. I mean, what's going to be super interesting is when trial starts, Bradley, I believe, unless there's some sort of motion I'm not aware of, can get called as a witness. And at the very least, Moretti's going to get called as a witness, and they're going to bring up his shenanigans. So that's going to be interesting to see. Mandy says we need an interpreter who speaks underwater basket weaving. Yep, Amber. Lack of due. Ashy Snow giving out a sub to Jovion 3-5. Thank you so much, Ashy.
Thanks a lot, man.
Oh, I think Kyle has. So, guys, I figured out. I think when I set up the Welcome to the Jungle, for some reason the program only accepts it for YouTube. So it did come on. I think when I get new subscribers on YouTube, it does Welcome to the Jungle. But for some reason, I can't change it for Kick, which is a bummer. I mean, I guess the Kick ones are good too, but. Well, while we're waiting, why don't we do a little thing I like to call a raffle for a JBN glow in the dark. Is it when you guys, I mail these out, when you start getting me, let me know if you check if they're glow in the dark. I've never checked. Let's do a raffle for a JBN glow in the dark sticker. So when I tell you to, which is right now, type in the chat. Doesn't matter what platform you're on. Type in JBN, and then we will do a contest. And if you happen to be a subscriber on Kick, you have two times the chance of winning. So type JBN. But it doesn't matter. If you're on YouTube, you can do it too. The OCPD coach says the new prosecutor is the same lady from the XXX Tentacion case. Thank you for the info, the OCPD coach. All right, remember, folks, type in JBN if you want to win a JBN glow-in-the-dark sticker. Just make sure I have this on so we don't miss anything here. Oh, it's not live. Shit. Oh, my bad. Hold on. All right, let me pause this and do the giveaway real quick. All right, everyone put it in. And let's go. Laura, congratulations, Laura. Email me, theshamingofjay@gmail.com, and I will get you out your sticker. Let's go back. What? Oh, Shannon has yours. Never mind, Laura. Congratulations on the win. Let's go back and see what's going on here.
Kind of. There was a suggestion of bringing the paneling in the morning and recessing in the afternoon so that the state can get up to speed. We could live with that if the court but we proposed another alternative, but they need to talk to the higher ups. And may we approach? Sure.
Bring the TV up so that Ms. Liberty can approach. Bring up the TV. Ms. Liberty can't hear.
As far as starting with the jury selection, counsel Claire asked a question, and I just indicated maybe we should go back to the podium so we can talk over the court here. So the defendant is here, but I mean, you mentioned about a larger courtroom. I am able to get one if you want that one. I don't know if you do or not, but if you think that's a good idea. I've talked to Judge Rubolo at this courtroom. It's the two-door down. It's the juvenile court. 4840, so that's Bill. I just have to let him know. He said to accommodate whatever I wanted. I did speak with the jury room yesterday. They have jurors that they review tomorrow. And we can do that if you just get a large panel. I think we originally thought when Ms. Bradley was still on the case about going over there, we were bringing 100 jurors at a time. So I don't know how many fit in there, but we might be able to get even more.
Your Honor, I recently tried a case in there with Judge Yukon. That took a couple of months, and we utilized some of those courtrooms. We did about 5, maybe squeezing 70 jurors at a time. So that's kind of.
That's when I tried first. We were in that same type of courtroom, but on the fifth floor, they're identical, and we were able to squeeze in 70 of those numbers.
I thought, Gary, when we went over there, we thought it was close to 100. That's 100? I have to look at that. I'm not saying for the, no, actually it wasn't textbooks. I'm not saying for the whole, I guess we could have it for as much as jury selection as we want, but I was thinking, or at least preliminarily, trying to get the, just going through hardships when you're losing a lot of people. She said we have this quote whenever I want it for, how long I want it for, and I said I just we want for some or all of the jury selection, whatever we want, they'll accommodate for us. So, we can. Gary, later again today, to see how many jurors we can get. Travis and I was. Counted out, but I told him to do that. Already, because again, you may think different. You walk over and back yourself.
We've had a problem in that courtroom, which is the fact that the change on the defendants and stuff like that, I don't know if they were still beyond the cup. And that's why I think we had to limit it to the amount of people, because you couldn't put the prospective jurors in a position where they could see the change in the cups.
How we can do that this time?
Well, the last time, he wasn't choosing the cups. If you pick a jury, he's going to be street vote.
Yes, yes.
It's not going to be.
Yes.
up for judge.
Very good. And it's just one defendant as opposed to the three or six.
So if we can fit 60 a year, I'm sure we can get way more than the same amount.
That's right. That's right.
We're rolling.
We're rolling.
Just in there.
We have the same numbers, but we're wrong.
Your Honor, we're fine with whatever, works for Your Honor. Obviously, we're agreeing with the larger courtroom that was allowed more room for the state to have another table. Obviously, it's smaller for the three of us. There's multiple defense counsel and those tables in there are bigger for defense counsel as well. And then obviously, there's more jurors to see their availability.
If you try the case from here, it is not sufficient for you, you can continue to do it.
If we could have a bigger table, we're fine, just because there's three of us, which is, but otherwise, whatever works for Your Honor, we will make it.
I will read it, and I spoke to David Bowl, and we asked him not to report it. I always told him to try the case.
That's fine, we'll make it work.
I'll help you find out if he's looking to. So, I was looking at these dates, trying to come to some understanding of my own way. If we went through and we started just for the hardships, going over the dates, and see how many jurors we get. And what is a magic number of jurors that you thought?
Oh shit, just got a coffee from Betty, says enjoying your pod. Thank you so much, Betty.
We're fine with that, Judge.
It's in the financial cost, you can hire a
So if we come back, if we put it through here, we keep it 19 and we're through this term. We start with the hardships until we have that magic number. We'll see we're on the high side, 150. And we want to do, how many people would we want to discuss this with? Trying to speak to everyone smaller and larger than 100. So it's 150. And you want to keep the smaller actions smaller. Really suggesting 25.
Rather than death on cases I've tried, we've always had like 50 to 60 at a time that we could get in the program.
So, if you're away, we wouldn't need the role of holding the instructor session. Pretty good.
So, thank you.
How long do you take the question? Who's going to do it?
General Honor, Mr. Benjamin, and the death qualifying for the son.
Your Honor, again, because I don't know the issues of the case, I could not even begin to approximate the amount of time that I would need.
Who's going to do it?
Me.
You're on both minutes?
That hasn't been discussed yet, but likely. potentially one of them would be a good penalty to study.
So, assuming that that's what it takes, we do it here, we have a somewhat small, I don't know if we want that 20, 25 years, we've never done that respectfully before. Except on a small case, we, assuming we did that, we came back a year for it, and we broke it up into groups. Even if it's 50, you're talking 3 different board hires. And that's for each, both the member phase and for the board hire, right? And if you're doing that and you're splitting it up, correct? So I'd say once you do split it up, well, not so much the person doing it, but the standard board hire and then the death penalty board hire, you know. I've never done it where it's all mixed in, to be candid with you. Because I don't see any reason why I couldn't even that way, but I've never done that. We've always broken it up, and I think in the last trial with Ms. Bradley here, she wanted to do the death penalty portion first, and the defense didn't. Forget which we did first.
We did general law hire first, and then death qualified.
I think Ms. Bradley thought of including more people in the death penalty. We did that first. That was her thought process, I think.
And I think the court agreed with what Ms. Bradley was picking up the case to do general law hire first, and then death qualified.
That's what we did in the last trial, but what's going to happen in this
No,
trial.
I understand.
I believe that Ms. Bradley wanted to that portion done first, only thing done first. So we think about that, and we'll talk about it sometime. But it would seem to me that we were just going to be in a couple of days just trying to get up to 150 jurors, hardships, and I don't know how much detail I'm going to do on here for one trial, obviously, so 2 or 3 defense counsel on here. But we went through a written question where I asked the jury to go through the questionnaires, and I also did attorneys announced witnesses, and this time we have long witnesses. You're going to read it? How do you want that done? You'll read it?
Whatever the court decides.
I'm asking you.
So are we going to read it at the time you're just time qualifying them, or you're waiting, you're saying?
I'm going to wait.
Okay, that's fine.
My thought is, I think the last time we did it, I gave some, I did read it then, as a statement, I read the charging document. I'll probably still do that with the preliminary instruction I'll give, no research, things like that, that no use of cell phone. I'll go through those, and it's really a silly instruction, just to explain to the party. But typically go back. One of my functions, who the terms are on the bridge view for the panel, like we did before. I'm not going to ask you a question about whether they know, I will ask a question whether anybody knows the defendant, but I'm not going to, if they do the work, if they know the defendant, or the defendant, or know the case, we could bring them up to time. Initially, by trying to stop them, they seem to say something. So I'm just trying to raise their hand and say, listen, alert to that issue, and then we bring them back to the court. How long is the trial going to take?
I have no idea, it goes back to allowing us to have someone that's there, because that might streamline it, maybe we'll get rid of some of them, and you know, so again, you don't know what happened in the first trial, we're catching up now, so thank you. And bring up those for tomorrow, and probably do that in December, that'll give us some.
Instruction for any standard board item. We talked about defense, in the right, not testifying. Yes. Yes. Specific for instruction on, you know, reason without instruction, bringing evidence of legal consider, is that right? Yes, sir.
No, no.
All right, so we'll talk some more. Anything else to discuss now?
No, Your Honor, what time do you start at 9 o'clock?
We can't get through up here until about 9:30. So I'd say 9:30. And we'll be next door. So we'll go forward that regardless. We talk about it. But maybe a year a little earlier. Because you have some issues or something. Otherwise, we're looking.
Yeah. So I do have you guys to explain that. Just have one question for the court on the jury. Does the court have an idea of when those jurors, like tomorrow, can go through and for hardship and so many or evidence and back, an idea of when you might be bringing it?
I'm just, we have to get 150, my call would be, or put it on Gary and do his phone numbers and let them know that he's full. Do a sporadic schedule.
Yes, sir. So you want to give one other thing very quickly? So last Friday, when I had brought up the idea of the court doing an independent inspection of the investigation that was going on, that sort of was the how it happened afterwards, there was a question from the defense counsel, Ms. Liberty, regarding which investigation we were talking about. Yesterday, there was an email chain between juror J.A., myself, and Robert Trackman. Mr. Trackman was saying that he has an outstanding motion for his earned as a client. And I responded with, is that for himself? Is that from the investigation that was going on, where he represents the defendant's mother, or whether or not there was something that happened in this case that I don't know about? I did get a clear answer from him regarding where is it? So I'm not sure exactly because I didn't have access to oxygen.
Why don't you talk about that? It'll be a recess from them, give you a chance to talk about it. Before I let you go, Mr. Dennis, any discussion regarding settlement? There's no discussion, correct?
There's been no further discussion.
He hasn't offered anything?
No.
And you haven't?
We did offer something when we met with the state attorney.
We did that.
And they said they would get back to us very soon.
You're talking about the meeting you're having
Yes.
with the state attorney.
With the
Yes.
state attorney. Yes.
Sure. One last thing if I may. When I didn't know what the scheduling was going to be, I subpoenaed him tomorrow, Detective Craig. I just want to make sure I should call him off, because we're certainly not going to be doing any testimony and any motions for him. I just want to make sure that's the case.
If they want to swear in the panel, we can do something afterwards and bring the jury back, you know, a couple months later.
I'll cancel.
You're not ready on anything, correct? You're not telling me you're ready on anything?
No, Your Honor.
We'll do it. Mr. Devens? Mr. Devens? Good morning. Good morning. I appreciate you standing, and that's fine if you're comfortable with it, you can stand, if you want to sit, you can sit. It's up to you. So Mr. Devens, you've heard what's going on here, this discussion we've had, having, I just asked your attorney to review possible resolution in case they indicated that they had made an offering to
So they can
now,
print it.
seeking
If we could look at it
proceeding to judgment, you understand? And your attorneys also asked me to go forward on the trial. They want to move on the case. I brought up that pursuant to this notice to the court and the parties that was filed by the defendant, by the state attorney, Mr. Plaintiff, that there are 30 outstanding motions that were filed recently, the last 2 weeks or so, right? And there are 22 new state witnesses. Those new state witnesses have not been closed as of yet, and we haven't had any hearing on those 30 motions. I asked your attorneys if they're ready for trial, and they said yes, they want to go to trial, and counsel made me concern that they weren't asking for continuance and that they wanted their day in court. They also want the motions heard. Exactly how we're going to do that, but they indicated that they did not want a continuance, right? They wanted to go forward with the continuance. Did you hear that?
Yes, sir.
And have you had an opportunity to discuss that issue with your attorneys?
Yes, sir.
And they answered all your questions? Is this what you want to happen?
Yes.
So the reason I ask it, let's say things don't go well for you, and we come back and all these witnesses haven't been opposed, or all these motions haven't been heard, or something along those lines, and you're in the middle of the trial, and it doesn't go well for you. I don't want to, have an issue with them coming back saying, hey, my attorneys were ineffective, I made a mistake, or something along those lines, because they gave me bad advice, or something along those lines. That's what I get. So we've had an opportunity to discuss this issue with your attorneys about whether or not you want to take over the depositions first, or have the motions heard first, or not. We've had that discussion, correct?
Yes.
And they've answered all your questions. And this is what you want to do, right? You're on board with this decision, so I assume you're recommending it, I don't really know, but you're on board with this. You're in agreement with it, correct? Just like in the last round, right? Certain things I'm going to ask you about. We want to make sure we're all on board with the same things. It's your case, your trial, you're going to be able to counsel the third court here, and the court is more on the phone, on Zoom, this delivery, but it's ultimately your trial. I want to make sure you're good with it. All right, so periodically I'm going to stop and ask you, just make sure you're all right. Just like we did before.
We want to make it clear that since we filed a motion this time and sent it to the court order, we're not giving up that money. Oh, okay. I just want to.
Some of the motions expressed to be heard during trial.
Yes, absolutely.
During trial.
Yes, sir.
You evidence in.
Yes, sir.
We'll see what happens. I don't know exactly what he's doing. But again, I don't know if you have 22 depositions and you take those depositions and you do it ongoing during the trial and you say something in opening statement that you might not have said, if you had all the depositions done. I don't know what's going to happen.
We understand.
I'm always very cautious about starting something, very serious matter without availing ourselves of all the pre-trial motions and getting those things involved. So everybody knows what to do.
And Your Honor, if I may, just again, because we're coming in at the 11th hour, in our brief review of the case, and Mr. Griffiths just reminded me, we still have the new charges that Mr. Evans, new charge that he picked up. We're obviously reviewing that evidence, and we're going to be filing a decision. But it's my understanding, again, in my brief review of the evidence so far, that we can not see still evidence that potentially could come in this trial. So we'll make sure that any of those charges and decisions or motions we need to deal with that charge in this case is filed immediately. We'll read everything this week, so that could potentially, I guess, have the same effect that Your Honor just brought up on certain things that might take place. I also do know that one of the witnesses that was listed, the reason that witness was listed from DSO from digital forensics is because I guess there's going to be a warrant done on the vehicle to download some of the telematics. So that would be something that would be handling the person to get. I just wanted that on the record.
Well, it's just something that I'm trying to figure figure out how we're gonna handle this, and what we're gonna do, and why you're here from the first. I know you're worried about those technical conditions, so there's a balancing has to be done. Kind of has speedy trial rights, you have the right to due process, you have the right to a fair hearing as well. I understand all of these things, just trying to leave something that works.
I understand, Your Honor. I just want to make sure that, you know, the prosecution on the case, we're not violating our oath. We obviously have to be prepared, and God forbid something occurs in this case that we weren't aware of in the original case, we're going to end up in a position where maybe we don't disclose something because we didn't know about it. So we want to make sure that we don't get to that point again. We're here to make sure that this trial is done right, that there's no issues, and that's why we're three new prosecutors on the case. And so, I just did this in Judge Holden, AP Gregory Cunningham, where we brought the jury back during July, they came back in September. So we're just asking for a little bit of time. We will in no way, shape, or form have an advantage by that because Ms. Bradley lived in this case for 5 years and we're asking for a month.
Thank you.
Thank you.
See you tomorrow. You have stuff to discuss, right?
Have a good day, Judge.
Thank you. I appreciate it.
I'm going to whisper so people, I don't blow out your eardrums.
Take care.
Take care. Yeah.
He doesn't want to see us.
I don't.
Yes, sir.
Maybe we bring up a use for all the rest of it. But I think whatever you do is next door.
All right, folks.